Treaty of Geneva Convention, and as was stated in the Special Court of Sierra Leone in the Norman case, known as the child recruitment case, and in the Inter-American Commission for Human Rights in the La Tablada case, customary international law applies to all sides of the conflict, including non-state entities. Thus, all basic principles of international humanitarian law apply in our eyes in this situation, such as proportionality, precaution, and distinction. Please.
Please, Advocate Nizia, if you may elaborate on the matter regarding the attack on the ships at different effects on men, please.
Thank you very much. As we all know, at the night between the 2nd and 3rd of May, personnel placed miles, 32 nautical miles from the Perotti shoreline in order to attack our ship, the Vami Armora. We believe that this attack has violated severely international humanitarian law. First, it was out of Perotti territorial waters, and according to Article 3 of the United Nations Convention on the Laws of Sea, known as UNCLOS, therefore, we believe that the choice of location was in fact a miserable one, as it was in the high seas and not legitimate. More than this, we believe that the sinking of the ship in itself was illegal, as we know, the neutral ships may be attacked if they carry military material, but only if it's not feasible for the attacking forces to first place passengers and crew in a place of safety, which naturally didn't happen since they used mines, and can only be unless the circumstances do not permit the be given warning so they can reroute or take precautions. Naturally, this reflected also in the San Remo Manual, Article 67. This naturally could not happen because of the use of sea mines, problematic and probably legal in this situation in itself, mainly because there wasn't every possible precaution taken, and nobody was probably notified, as also mentioned, reflected in the San Remo Manual, since we believe that naturally if somebody was notified, the ship would reroute its passage, and also for reasons of proportionality and indiscriminate attack, we'll address that.
Please, Advocate Bohel.
Thank you, Ms. I will address the NRI operation in May 5th, 2011, which was in its method similar to the attack described in the case we described earlier of the Inter-American Commission of Human Rights, the La Tablada case. Firstly, we will discuss the targets themselves. The mostly accepted definition of military objectives is that these are objectives limited to those objectives that in their nature can contribute to military action. This rule is customary according to its codification in Article 2.6 to the Certain Conventional Weapons Convention, which was in the Second Amendment was elaborated to non-international armed conflict, and the state of Perotti is a party to this convention and to this amendment. In addition, Article 1, the second protocol of the High Convention, which is considered customary, provides similar protection to cultural property. In this case, there wasn't a use of cluster munitions or anti-personnel mines in the non-international armed conflict, and thus the contribution to military action was not fulfilled. In addition, the attack was against a port, a civilian port, even if there is a military target, if it is a military target, which we, as we said before, it is not. According to customary international law, it must some basic principles must be applied. I will address three of them. First of all, precaution. The weapon itself, when used in those civilian areas, is incapable to distinguish between civilian and military objectives, because the weapon used was a mortar from a distance and a mortar is, as you know, an inaccurate weapon. So we believe that regarding to this weapon is illegal per se, in analogy from the International Court of Justice, advisory opinion on the legality of the threat or use of nuclear weapons. The fact that it was used from distance enlarged the violation. This is derived from customary international law reflected in Article 3.9 to Amendment Protocol 2 to the Convention of Certain Conventional Weapons, and in addition, it is reflected in the Committee of the Red Cross, International Committee of the Red Cross Research on Customary International Law. The test of identification with bare eye, which was applicable in the NATO, the first report to the prosecutor made by the committee, established in review of the NATO bombing campaign against the Federal Republic of Yugoslavia, which demanded that if you are bombing from high altitude, you must distinguish in your bare eye the target. In this case, the distance between the target was so far that we don't believe that it could be identified in bare eyes.
You may address also the use of the flag of the CGNI. As time allows us to address it, we will address it now.
Thank you, Ms. I'd also like to finish the argument before about the proportionality and indiscriminate nature of the attack on the ship. We believe that as a customary rule of international humanitarian law prohibits launching an attack which may be expected to cause excessive harm or injury to civilians and civilian objects, as we know, this attack caused fire to other ships, caused death and injury of the sailors. And
you have 2 minutes remaining.
Thank you. And massive destruction of property, and we believe it was not proportional and naturally indiscriminate, since there was no way to distinguish the nature of the ship attack. More than this, about the use of Fijian flags, we just wanted to clarify our position that the prohibition on the flying of a false flag it's only prohibited during an attack, as reflected in the San Remo Manual, article number 110, and also in the first additional protocol to the Geneva Convention. And even then, in this case, a commander of a warship is allowed only visit and search before the attack of, in such case, which naturally didn't happen in this place, and naturally the NRA could not be treated as a warship. And only after all other steps possible taken, again reflected in the San Remo Manual, and didn't happen in this case.
You've got 1 minute remaining,
Okay,
so could you perhaps address us on Runny Sunday?
Okay, please, goodbye.
Yeah, I didn't hear you, I'm sorry.
Okay.
Are you going to address us on Runny Sunday?
This on Runny Sunday, you mean our operation?
Yeah.
Runny Sunday, you know.
Yeah.
Do we need to go into more detail?
I believe we will address it in our second argument. I just want to address, in addition, the fact that large parts of the port that I mentioned before was devastated during the attack of May 5th, and this is clearly unproportionate.
We just want to say that we have elaborated on these matters because we believe that there are the background, and the significant background to the events that took place on Runny Sunday, and we will elaborate after hearing our distinguished colleagues from the NRA here.
Thank you very much.
Thank you.
Well, let's hear from CCP NRA representatives. What are your view of the, what in your view are the salient legal issues here before us? You have 10 minutes. The floor is yours.
Yes, thank you, Mr. Chairman, Madam Chairman, dear fellow delegates of the Canadian government. We are here to represent the Naya Ronda Alliance as well as the Toluca Carnival Patriots. My name is Katja Knechelman. To my right, Ms. Bahalal. To my left, Mr. Weinstock, who also advisors for the NRA and TCP. We are very glad that this Reconciliation Commission has finally taken up its work, and we wish to cooperate with it as much as possible to bring justice to the Northern Canadian people. And we also wish to help it in discovering and revealing the past wrongdoings that have happened during the hostilities of the conflict. Especially we will address the happenings between 2nd and 8th of May as has been proposed. We will address today several issues ranging from the qualification of the conflict during the month of May 2011, as well as the establishment of our status on the 5th of May of 2011, which has been forgotten by the Peruvian government, I believe, and also the wrongful acts that were committed by on behalf of the Peruvian government by their militaries. Finally, we will, if we have time, also address some of the issues and wrongdoings that have come up as accusations against the Nairobi Alliance and TCP. Mr. Chairman, Madam Chairman, due to the complexity of the situation, we will begin with the qualification of the conflict, which we believe is vital to the rest of this discussion. We believe it was a non-international armed conflict until the evening of the 5th of May 2011, where the law applicable is, as we probably all know, Common Article 3 and applicable customary law to non-international armed conflict. On the evening of the 5th of May of 2011, our General of Llevado declared independence, and we established our statehood as the Democratic Republic of Northern Peru. We believe this is very important. As a result of that, we are in a situation of international armed conflict between two states, which changes the scope of law that needs to be applied, meaning that the all the Geneva Conventions of 1949 start to apply, as well as other customary international law applicable to armed conflict. Ms. Bahila, please elaborate on why we believe the statehood establishment was
Thank you. The Democratic Republic of North Peru has fulfilled the four criteria as stated as enumerated in Article 1 of the Montevideo Convention on the Rights and Duties of the State from 1933. It has a permanent population, a defined territory, government, and capacity to enter into relations with other states. I would also like to mention that it was recognized by three states, Micronesia, Nicosia, and Kiribati. Thank you.
Mr. Weinstein, please elaborate on the events that happened on international waters.
Thank you, Mr. Chairman, Madam Chairman. We're pleased to be here. With regards to the issue of the Vami or Murma in international waters, I'd like to first start by saying that the ICTY Galich case says that one has to look at the situation ex ante and not ex post, meaning that one has to look at the information available to the commander in the field at that time. And additionally, according to the 1982 Convention on the Law of the Sea, territorial waters only extends at most 12 nautical miles from the baseline of our shore. Therefore, we were in international water where it is indeed legal to place mines. With regards to the use of the mines, they, according to the San Remo Manual on International Law for Armed Conflict at Sea as of 1994, mines may be used for legitimate military purposes, including the denial of no areas of no sea access for the enemy. Additionally, according to the San Remo Manual, although it is not binding document, it is a leading document on the laws of war in sea, as the previous laws have somewhat been outdated as time goes on. We determined the enemy character of the ship by the intelligence that we had. With regard to the flag of the ship, although we understand that the goods were manufactured in China, we do not know that they were indeed shipped from China. It is very likely that they went to Fiji and came from Fiji. With regards to the fact that cluster munitions were on the ship, I would like to remind everybody that Peru is party to the Cluster Convention. Article 1 states that no state will produce or otherwise acquire cluster munitions, which is a violation of international humanitarian law. Additionally, although Fiji is not here to represent themselves, they are a party to the Cluster Convention, and they too are not allowed to distribute cluster weapons. With regards to the military objective, there is the state of Peru mentioned customary law, and there is, according to the customary study of the ICRC, which we duly respect. However, there is notable criticism from that, mainly regarding military objectives, that Article 52.1 of the First Additional Protocol, where the customary study takes it from, says identify civilian objects through exclusion as a military objective, meaning that it is, if it's not a military objective, it is then civilian. We take a position that military advantage is anticipated from an attack as a whole and not just one particular aspect.